Hello, once again. We are coming at you from the California Applicants Attorney Convention out in Carlsbad, San Diego area. And we would like to send thanks to Castillo Montes and Associates because they're the ones sponsoring these spots. And thank you so much for this gift of being able to sponsor these meetings. And right now, I'm speaking to Tim Chan. Tim. I mean, you work for Michael Burgis and Associates, and he's an awesome guy. He's very very well known, and he's growing a lot.
Absolutely.
So, tell us what you do.
Yeah. So I'm one of the trial attorneys, one of the senior attorneys there at Michael Burgis and Associates. We also call it MBNA. That's the logo that we go by. And we have 3 offices. We've grown quite a bit, even during COVID. A lot of the offices weren't able to meet that challenge. But Michael is super innovative. He also takes a lot of risk, kind of doubled down even during COVID. So we have 3 offices now. We have one in Sherman Oaks. We have one in Pomona. And then our most recent office has been in Commerce. Still looking at some other areas, but those are the 3 offices. We wanted to reach the different locales where our clients are generally hardworking, blue-collar workers, where they're going to be mostly located, and just want to be able to reach and be available to a lot of our clients.
Most recently, what's the newest office? Is it the Pomona office?
Commerce.
So that's the newest one.
It's our newest office from maybe 2.5 years ago.
Yeah. And I mean, you've been growing a lot. I mean, out of that area too. You just moved. I mean, like maybe within the year?
So we moved different offices in Commerce, but we've been in the Commerce area for maybe about 2.5 years. Already. Yeah.
So basically, now Michael Burgis does workers' compensation.
Mm-hmm.
He does personal injury, and he does labor law.
Employment law, yeah, exactly.
Employment law.
We focus on all different kinds of discrimination, but specifically disability discrimination. A lot of our clients, once they're injured, then the employer doesn't want to have to deal with the repercussions of someone that's injured because of the work that they're performing, and they'll either terminate them or they'll demote them. And so what we do is we want to enforce what the labor laws are under the California Labor Code to protect our clients.
Tell us about discrimination of the client. What can be some forms of discrimination at the workplace?
Yeah, absolutely. So when there's an injured worker that's injured at the job, and what happens is they have a work restriction from a doctor saying, for this time, no more lifting more than 20 pounds, no lifting more than 25 pounds. And the employer will basically come up with some kind of reason, a pretext, oftentimes, that they either can't accommodate that worker, even though they really could accommodate that worker, or they'll say that, hey, we're closing down this department and this job is no longer available, and they'll take off all the job listings. Maybe 2 months later, we'll find out that they're actually looking for the exact same job. So as a pretext, saying that we're just closing that department. So lots of different ways because they don't want to have to accommodate injured workers. As we know in California, they have to make a reasonable accommodation anytime that a worker comes to them with a disability.
Right. So would that be the 132A, or is that something else on the law? Or
no, it's a civil claim. It's not limited to workers' compensation.
Okay.
There is a lot of overlap with 132A claims. So there's a lot of overlap there, and you could potentially file a 132A claim. But we're talking about filing in Superior Court or in federal court, and we have a lot of cases that are either in arbitration or actively going to trial right now.
Okay, so it's a different aspect of law. I mean,
Absolutely,
per se. And workers' comp. So, can you tell me? I know you can't talk specifics about any particular case in chief, but how does a worker become compensated for and how much of a compensation? Is it the same as workers' comp or different than workers' comp? How does that differ?
Sure. So, workers' compensation. It's an administrative law section, and so it's under the exclusive remedy. There's only limited what you can recover, right? So it's generally temporary disability, permanent disability, medical care. There are vouchers. There's getting reimbursed for medical care, medical expenses that have already been, laid out. If an injured worker is dead or passed away, deceased because of the work, there's a death benefit for the people that were dependent upon them. But when we're talking about for someone that is wrongfully terminated, discriminated against, or the employer didn't conduct what's called an individual interactive process. So if they come to them with a work note, you're supposed to hand it to the employer, HR. The employer is supposed to review it, talk with the injured worker, see if they can accommodate them. What are those restrictions? Can we accommodate that? Here are the job options that we have available. And if they don't do that, that is a claim. So yeah, what are the damages that are available? It's any kind of civil damages that are available. So that could be lost wages. It could include pain and suffering. It could include lots of different claims. And generally, the damages that are available are going to be greater than what's just available in workers' compensation.
Now, an employee may not know that such a claim may exist, maybe following a workers' comp claim or whatever. How does an employee how can he or she determine that this is in fact a claim that they can claim under labor law?
Sure. Ultimately, it's going to come down to the same attorney answer, which is depends, right? So definitely talk to your attorney, come talk to us, and they'll be able to figure out whether it's limited to a workers' compensation claim, it's exclusive remedy just to the damages I kind of briefly recapped just right now, or otherwise there are some exceptions. We actually just came out of a conference where they were talking about some exceptions where you can sue the homeowner or you can sue the general contractor, but this is a completely separate type of claim. It has nothing really to do with the injury itself. It's what does an employer and what are the employer's responsibilities once they know that their employee has a disability, and what does the California laws require of them?
Very, very interesting. So you just touched on an issue that is very sensitive, and I can see a lot of our clients go through this.
Sure.
When they're working for an construction company and they are not insured. So then you file a suit against the homeowner's insurance. Mm-hmm. How do you mix those things? When does an insurance company for the home become liable for the work injury that happened at that place?
So those are a little bit two different concepts. What we're talking about is an employer and discrimination. It's not necessarily talking about going against the homeowner's policy, right? So what we're talking about is, again, if there's someone that's working, it's an employee that has a disability. That could be either from work, so they were injured because of a workers' comp injury, right? Injured arising out of the course of employment. Mm-hmm. It could even be something else. It could be even that they have cancer, maybe not even related to work. Anytime that you hand in a work restriction note, a doctor's note, a lot of people just call it, hey, a doctor's note, there are certain obligations, responsibilities that the employer has to then take under, right? And so they have to make a reasonable accommodation for their employee. And so there's a whole long process of what they need to do. They have to conduct an individual interactive process, what that work restriction is, if they can accommodate them. And then if they can't accommodate them, they have to make a reasonable accommodation. So there's a lot of analysis that goes into that. But that's one of the scenarios, and those are some of the cases that that a lot of times overlaps because we represent employees that are injured, right? And so oftentimes they do have work restrictions and doctor's notes. But that side of the practice is not just limited just to
employment law,
not just limited to disability claims. We also have sexual harassment claims and lots of other claims. So just any kind of discrimination claims, wrongful termination claims by an employee against their employer.
So that's very important. That's very important for the listener, for the viewer to understand that a case may not only be a workers' comp case. There may be some overlap sections of whatever they may be going through. I mean, sexual harassment or whatever. They may be tapping into another aspect of law, and from what I understand, that could be more, I guess, better compensated than workers' comp injury at times.
That's definitely possible. We were in, I think one of the things that I've learned from Michael Burgis, who's my boss, which I love about him, it's one of the reasons I'm working here, because I have, I have options to go other places. It's happened. Many people have made offers, but I stay here because I just love the creativity and the how should I say, the big picture approach that Michael takes, and I've really learned a lot from that. For example, we just came out of one of the panels, and they discussed something called the bunkhouse. And I don't want to go into too much in the details, but because I don't know those specific cases, but I think one area that the attorneys could have screened was not only a workers' comp claim, but also whether there were wage and hour violations because they were still on the clock if they had to live on the facility or live on the grounds for that employer. So I think just understanding many different areas of law, understanding how they cross over. I think oftentimes attorneys, when we focus on one area of law, whether that's workers' compensation or employment law, disability discrimination, or just wage and hour, if you just focus on it, you're only going to see how you can work up your type of case. But I think I really appreciate our firm that we really take a lot of time, even internally training for lots of different areas of law, whether that's personal injury, discrimination, disability discrimination, wage and hour, just see how they all interact and overlap so that we're really doing justice by our clients. Because if we know that there's different types of claims, or maybe if we don't know, that's, arguably we're not representing our clients in the right way. Does that make sense?
Yeah,
sometimes we can hyper focus on just workers' comp claim. How do I get this workers' comp claim to maximize that, as opposed to when they could have had other claims? And that's really important, I think, for your listeners to know about, and also for attorneys just to really be understanding that we're in a special place with special information that sometimes injured workers don't have. Does that make sense?
Yeah, absolutely. No, it's the more broad you are in the aspects of law that you can manage, the better you are. And I know Michael. I mean, I think I met him like 20 years ago or something like that. He was working for a firm in Pasadena. I think I want to say, I forgot the name of the firm. But I met him since then, and every time I hear that something is going on, it's always he's growing, he's popping over here, and whatever. So I'm so glad for him. I'm definitely glad for you because you seem to have job security.
Absolutely.
Even though you're an attorney, you can go many places.
Sure.
But tell me, I don't know if you are much involved with PI, personal injury. I mean, are you involved with personal injury at all? Or
not me personally. Primarily workers' compensation and the overlaps when there are cases of like disability discrimination.
Okay, so that's very important to know. So a case can be workers' compensation, but it may also be other aspects of law. If there's sexual harassment or discrimination or wage and hour. For example, I mean, I heard of this one. This is a friend of mine, particular friend of mine, that basically says, hey, you know what? I mean, he calls me and hey, I'm going in on Saturdays, but the boss pays me cash. He so during the week he gets a check, and Saturdays he gets cash. Tell me how would you see a claim like that?
Absolutely. Well, I mean, you have to figure out whether an individual is working more than 8 hours in any workday, whether he's working more than 40 hours in a work week. There's also their mandatory breaks, right, like lunches and whatnot. But I think, again, everything's going to be very, fact specific for that individual and that situation. And I think that's the big picture would be just, hey, is there something different happening? Why are you paying me check during the week and then cash on the weekends? Yeah. It's not generally for the employee's benefit. It's generally to benefit the employer.
Yeah.
Right? And so I think just with that information, sometimes there might be a reason for that. I don't know for that specific, what was going on there. So I think the best thing to do would be like, hey, if you have questions, then just take it to someone that has the information, has the knowledge to know how to analyze it. Does that make sense?
And I have told them, you know what? I mean, you got to speak to an attorney about this because this is not only has happened like 1 or 2 years. This is 30 years of doing the same thing, and he's working a full week, full time, and on Saturdays he's working 8 hours. And so the good thing about what he's doing is that he has been saving his parking tickets for every Saturday, and so he happens to be he works at UCLA, and I mean, they park right there, and whatever. But I mean, I think it's very fishy that the employer is doing that. For 30 years, I mean, that's something going on right there. But I told him, hey, you know what? Talk to an attorney. I think there might be something there for you, but
generally there's something a little weird. If there's smoke, there's generally the fire. It's causing the smoke. So
yeah.
That's definitely what I recommend.
Yeah. So you know what, Tim? Is there something else that you would want to tell that you maybe something that you learned here at the convention, or something that you would want to tell us about you? Or
about myself?
Yes.
Yeah, I think I'm just very appreciative for the opportunity to be in this special area of law, that we can really help people that don't always have the knowledge, whether that's hardworking immigrants, whether that's people that are just really focused on their field and they don't have time to really focus on the law. Perhaps sometimes employers will do things that will engender a lot of loyalty because they want to be able to sometimes take advantage of them, like paying them cash on the weekends, not having to pay overtime, not paying them for their breaks. And so I really feel very privileged to be in this position to help people that don't have the knowledge or don't have the ability to be able to help themselves. So I really take a lot of pride in that, and I feel very blessed to be able to represent injured workers, people that are discriminated against, and to be able to use the law for its intended purpose, to protect the people that really need the most help, right? Because the laws are not there for people that have all the power and resources to get whatever they need done. It's to make sure that the people that don't have that power and don't have access to that information are protected. So the vulnerable people in our society. So I feel very privileged.
And I'm going to ask you one last question, and this is something that I have addressed with many people here. But what can you tell me, or how do you feel about an employee that is not reporting an injury? What can you tell me about that?
Not reporting an injury
to an employer.
I guess it depends how you. So, if they have a valid workers' compensation claim.
Usually that's the case. I mean,
Sure.
I talked to hundreds of people, and they told me, well, yeah, I got hurt doing this, doing that, and I'm like, did it happen at work? Yes, it happened at work, but why didn't you want to report it? Well, because I need the job.
Sure.
And it goes unreported for 16, 17 years. I mean, that's what can you tell me about that?
Sure. I would say probably two things. All right. So one is that if you have a good, fair, honest employer, they would understand that if you bring a workers' compensation claim for a valid claim and you actually are injured and you need medical help, a good employer would not have an issue with that. Does it negatively impact the employer? Is it going to maybe cost them more on their XMOD, on their insurance, how much they're paying their premium? Absolutely. I mean, that's totally a possible outcome. But any good employer would not have an issue with that, right? Because they want to make sure that their employees are taken care of, right? As opposed to if your employer does have an issue with that, maybe you have to think about that's not the right employer that you should be working for, right?
Correct.
There are realities of having to put food on the table, take care of your family, and I get that. But I think sometimes people maybe have a loyalty or some fear with a certain job. They don't want to expand their borders and expand what's available to them. So that's what I would say for that. Like, it might just cause you to question whether you even really want to work for that employer, right? The second thing is that if you do file a claim and are assessed work restrictions, that's when some of those employment law protections come into place, right? So in fact, you could actually be protecting your job by filing a claim, because once you have a doctor's note, you provide that to your employer. If they're now worried about, hey, you filed a workers' compensation claim and they terminate you, that's oftentimes going to be an employment law discrimination claim, and it's something that either our office could help out with or another employment attorney can help you out with. So even though sometimes they're a little bit worried about filing a claim, that might be the way to actually protect you from any kind of adverse employment action, whether it's demotion, not getting the hours that you were originally getting, or maybe ultimately getting terminated. So actually that might be the way for you to protect your job. So that's something you could just talk with the attorney about. What does that look like? What is the landscape of what could happen? Does that make sense? So
the key component here is talk to an attorney. Don't be afraid. I mean, a lot of people are afraid of you. When you, in fact, you would just only recommend things to them. I mean, you're not going to make a decision for them, but you will recommend things that might be in their benefit.
Absolutely. So oftentimes you can go to an attorney and just consult with them. It's a consultation. Most of the time it's a free consultation, right? And we can't file the claim unless they sign the paperwork, they want to move forward with it, retain an attorney. So absolutely, get the information. I think if that's, if I could have one takeaway, it would be just get the information by speaking to an attorney. Because otherwise you'll never know what was available to you, what the protections would have been.
Thank you, Tim.
Absolutely.
Thank you so much for this interview. And once again, I want to thank the offices of Castillo and Associates. They're the ones that are making this possible. And Tim, thank you very much for your knowledge.
Absolutely.
Thank you for sharing with us.
Absolutely. My pleasure.
Okay, thank you.
All right.
Bye.